It's a very special opportunity for the law school and for all of you to have the opportunity to hear from the Solicitor General of the United States, who I'm told, by the way, is also speaking at the commencement a week ago at the University of North Carolina. So it's better he came to the United States first before he went south. Let me introduce him to you. Solicitor General was born in New York, I think New Rochelle, New York. He grew up in Connecticut. He went to Yale University. After leaving Yale, he went to Columbia Law School, where, as you might expect, he had a distinguished academic career. He was editor-in-chief of the Columbia Law Review. Following Columbia, he clerked on the D.C. Circuit Court of Appeals, which is the mini U.S. Supreme Court, for Judge Skelly Wright, notable. And then from there, he clerked on the United States Supreme Court for Justice William Brennan. Went to work for Jenner and Block, did pro bono work from that vantage point. He worked at the Department of Justice. He was deputy counsel to President Obama. And then in 2011, the President nominated him to be Solicitor General of the United States, which requires Senate confirmation. So he's held that position since June of 2011. It's a pretty distinguished office. Justice Kagan was Solicitor General before Mr. Verrilli. Thurgood Marshall was Solicitor General of the United States. Archibald Cox was Solicitor General of the United States. It's an extraordinarily important, visible office. For many lawyers, to argue a case in your career, to be admitted to the United States Supreme Court, let's start there. Even if you never argue, that's a very big moment in the lives of many lawyers. To argue a case is a terrifying moment. A pretty extraordinary moment. The Solicitor General has argued 36 cases, all of them important, some of them very visible cases. But it's an extraordinary achievement. And when I look back over his resume, I thought he should be at least 100 years old. As you can tell, he's not. What you'll find today, and I don't mean to embarrass him, but I'm going to say it anyway. He's been here a day. He's been very gracious and generous with his time. And you will see at the end of the hour why he's extraordinarily effective in what he does. Because he's extraordinarily humble, grounded, and practical, and obviously smart. But I'm as impressed by his personal qualities and by his professional accomplishments. And when you meet people at the top, wherever the top may be, that's what you hope to find, most often find. And with the Solicitor General, it's true. So it's an honor to have him here, Professor John Graby. Students know him, family may not. He's a professor of constitutional law here, very well regarded. Clerked in the federal system at the trial court and on the First Circuit Court of Appeals. No small accomplishment. He's a scholar of the First Order, a great teacher and a great colleague. And he's getting better at conversations here too. He's doing more of himself. Anyway, welcome to this moment. I also, before I sit down, some of you were upstairs at breakfast, some of you may not have been. Chief Judge Jonathan Lippman of the New York Court of Appeals, which in shorthand means the top judge in New York State, and one of those people I most admire in the state court system of America is here. So this classroom seems pretty smart today, particularly smart in the conference. So anyway, enjoy the time. Hopefully you'll ask questions. I know that the Solicitor General, John Graby, would like you to participate. So enjoy the time, as I will too.
Thank you, Dean, and thanks to all of you for being here this morning. I know when I was in law school, I regularly had the thought of, oh my gosh, I can't believe there's another hour to go. Now that I'm on this side of where you are, I'm like, oh my gosh, I can't believe we only have an hour. So I want to just jump right in here, reiterate the thanks and the appreciation. You've been incredibly generous with your time over the past couple of days, and it's just really a great, great honor to have you.
Well, I'm really enjoying myself, and it's wonderful to be here.
Well, thank you. I thought maybe it would be most helpful to start by just giving a little bit of a thumbnail sketch of the office, your responsibility, and if you want to say anything about the history of the office,
Sure.
that'd be
Sure.
terrific.
Happy to do that. The Solicitor General's job is to represent the United States before the Supreme Court. The office was founded in 1870. Actually, before 1870, not only was there not a Solicitor General, there was not a Department of Justice. The Attorney General, position of Attorney General was founded by the first Congress in 1780s, but the Attorney General basically had to do the job of the legal function of the United States government essentially alone for almost the first century of the country's history, and as a result, what the Attorney General would do when the United States had to litigate cases in court was hire private lawyers to litigate them, including in the Supreme Court. And one problem that arose was that the different private lawyers each had a different idea about what position the United States should take on legal issues. So you'd have private lawyers on behalf of the United States taking opposite positions from each other all over the country, and that included in the U.S. Supreme Court. And eventually the country got big enough and the government got big enough and the problems got complex enough that they just decided this state of affairs was intolerable. So they created a Justice Department to basically run the legal function of the government, and they created a position of Solicitor General, who by law must be, the statute says that Solicitor General must be learned in the law. The only official in the government who has to be learned in the law to be qualified for the position. But I'm not the only official in the government who is learned in the law, I'll point out. And the first Solicitor General was a guy named Benjamin Bristow, who was, it was an interesting thing, he was a great civil rights crusader. And the second Solicitor General was a guy named Samuel Phillips, also a great civil rights crusader. They were both appointed by President Ulysses Grant, and Grant did that for a reason. He was trying to make a point after the Civil War that the rights of the newly emancipated slaves were going to be protected. And both Bristow and Phillips had really made names for themselves as great civil rights enforcers when they were United States attorneys in Kentucky and North Carolina, where they came from. And then over time, really the office evolved from that initial sense where they were really picked to advance a particular point of view on the part of the president to an office that has much more of an independent character, in the sense that our responsibility is to not to engage in advancing the partisan agenda of the administration, but to represent the interests of the United States over the long term. And that is what we do. And we do it principally by representing the United States in the Supreme Court. And it's quite amazing. You know, we've got in our office, very small, we've got an SG, principal deputy SG. Those are the only two political appointees. And there's 3 career deputies and 16 assistants. So there's 21 of us. And the 21 of us get done the following every year: 25 to 30 cases briefed and argued as a party on the merits in the Supreme Court, 25 to 30 cases briefed and argued on the merits as amicus in the Supreme Court, 10 or 15 cert petitions, 500 or 600 briefs in opposition to certiorari. And then another function of the Solicitor General is to approve appeals. Whenever the United States loses a case in the lower courts, the appeal can't go forward until the Solicitor General has signed a slip authorizing it. The United States loses a lot. We lose like 2,000 times a year, as it turns out. And now we win a lot more than 2,000 times a year, but we lose like 2,000 times a year. And each of those 2,000 matters, the SG's got to make a decision on whether the case will go forward. And you'd think that that was a rubber stamp kind of a deal, but it's not at all. People put a huge amount of work into making recommendations about whether appeals should go forward. A lot of times we'll say no. A lot of times we'll use that process to craft what the government's position will be, to try to, it's sort of a one way in which the office tries to cure the problem that the Justice Department and the Office of the SG was set up 150 years ago to try to solve. 140 some odd years ago to try to solve, was making sure the United States has a uniform position around the country that's thought through and consistent. And so, you think about that. 21 lawyers get all that work done every year. It's pretty amazing. And the budget's about $11 million, and that includes paying rent. And you think about that and compare it to what litigation costs from private firm these days, you see the American taxpayer gets really an amazing bargain from the Office of Solicitor General, all the work they get out of the office. It's really great. And so a huge part of my job, of course, part of my job is running that function and editing the briefs before they go in, and then the SG will usually argue one case in each of the 7 argument sittings that the court has, and then the other lawyers in the office will argue the remaining cases. But a huge part of the job is to actually figure out what the position of the United States will be, which can be a very complicated endeavor. And so it's a really, really wonderful job. Every lawyer who's had the job has described it as the dream job. Thurgood Marshall, who had this amazing career, of course, litigating all the great civil rights cases of the 20th century, and then including Brown against Board. And today is actually the 60th anniversary of the decision of Brown against Board of Education. And then he was also Second Circuit judge and Supreme Court justice. He said his favorite job in his career was being Solicitor General, and I understand why, because it's really pretty amazing job.
Just a quick question. You differentiated between merits briefs and amicus briefs. Could you just talk a little bit about the difference between?
So, 25, 30 cases a year, we're a party. It's either somebody against the United States or the United States against somebody. We've litigated the case as a party in the lower courts. But then in another 25 to 30 cases a year, we're not a party, but we will participate as a friend of the court. And when you're a party, you file a longer brief and you deal with all the issues in the case. We'll file shorter briefs. In your amicus, you file a shorter brief, but the Supreme Court routinely grants us permission to participate as amicus in the court and to participate in oral argument as amicus. And in those cases, we will, even though we're not a party to the case, we will make a judgment about whether the federal government has an interest in the outcome of the issue before the court. And if so, then we'll file a brief saying the federal government's interest is in the case coming out this way. Here's the legal analysis that justifies that outcome. Here's why the federal government has a policy interest in the case coming out this way. That can often be a case about how federal statute should be interpreted. It can be a case about whether federal law preempts state law, whole range of cases, but we can participate as amicus.
Thank you. By the way, I neglected to mention, you'll see that there are note cards at the end of the aisles and pens, so if any of you has a question that you would like to jot down, it can be delivered up here, and I'd be happy to, within our time constraints, try to ask it. I want to go back to a topic that you briefly touched on and then you talked a lot about yesterday and that you just described as a very complicated thing, and that is how the Solicitor General goes about determining the position of the United States in cases, recognizing our time constraints. Could you give just a quick little sketch of how that works?
I spent a half an hour talking about this last night, and I don't want to repeat that because we'll be done with the time if we do. I realize that.
Well, that's very interesting.
So, yeah, you'd think, so we have to figure out what the position of the United States is going to be before we can tell the Supreme Court what the position of the United States is. You might think that's an easy thing to do. You might think, well, the President appoints the Cabinet and the Cabinet appoints the Sub-Cabinet, and they would all have relative unanimity of views about what the legal policy judgment ought to be on any given matter in which the United States is participating. But that's not true at all. Turns out, and if you think about it, it makes sense, there are like lots of structural, institutional differences and conflicts that are baked into the system. Like, for example, the Copyright Office, which is part of the government, almost always thinks that copyright laws ought to be enforced rigorously, and copyright rights ought to be interpreted expansively, and they want the SG to argue those kinds of positions in front of the court. The Commerce Department thinks, oh boy, that's a threat to innovation, and they want copyright law sometime to be restricted and interpreted more narrowly. And one of the things that you have to do before you tell the Supreme Court what the position of the United States is resolve a conflict like that. And there's another one, a serious one, that I've been wrestling with my entire time in office. There's a real difference of view on the question of whether United States courts should be open for international human rights claims against officials of foreign governments. The State Department has a view that the interests of the United States are advanced by opening the courts to those kinds of claims because we show leadership on human rights if we do that. The Defense Department, the intelligence community have a very different view. They're worried that, yes, it's all well and good to have American courts open in that way, but if American courts are going to be open in that way, then foreign courts can be open in that way, and our soldiers or our intelligence officers can be pulled into foreign courts and be subject to prosecutions or civil liability in foreign courts that may not have the same guarantees of fairness and impartiality that our courts have. And so there's a real clash there, and part of the job as Solicitor General is to figure out what the answer is going to be. And there's no magic formula. I wish there were. I wish there were an algorithm that you could pop in the variables and press a button and have the answer come out. The position of the United States should be X, but there isn't. You just have to use your judgment. And then another thing we do is we have to really take. A lot of times we say no. We have a real gatekeeping function in figuring out what the position of the United States is going to be. Like an administrative agency might lose a really important case, like an EPA might lose a case in the Court of Appeals that invalidates a regulation that EPA cares about a lot, and there's some important principle of administrative law that led to the invalidation, and the EPA might say, this is an important regulation, we've got to go to the Supreme Court, we've got to get this regulation put back on the books, and we might look at that and say, yes, it's an important regulation, we get that. Yes, we agree with you that the Court of Appeals made a mistake of administrative law in deciding what it decided, but guess what? We're not taking this case to the Supreme Court, and the reason is because the factual scenario in which this legal issue is presented is one that's extremely unattractive, and it presents our position on this legal issue in the least favorable light possible. And because of that, the risk of losing this principle is sufficiently high that we're not going to take the risk in this case. And the reason for that is because if we take this case up and we lose this principle of administrative law, not only do you lose this case, EPA, but the entire federal government, every administrative agency will then be bound by this principle of administrative law that the Supreme Court decides that we think is important and we don't want to have decided wrongly. So even in a case where the agency is the client in the sense of representing, being the party in the case, we still represent the United States, which is bigger than that one agency. And if the interests of the United States as a whole conflict with the interests of that particular agency, the interests of the United States as a whole have to win.
One question that I have is, in recent years, there's been some controversy, especially with the present administration, about whether or not the executive branch is defending the law and executing the law in accordance with its constitutional responsibilities. And a couple of years ago, of course, well, I guess it was just last year, in the DOMA case, the decision was made by the Attorney General not to defend the constitutionality of DOMA. DOMA is the Federal Defense of Marriage Act provision or law that was litigated at the Supreme Court last June. I've heard you speak a little bit about this tradition and history of making the decision sometimes to exercise independent judgment about the constitutionality of the law. Could you talk to us a little bit about
sure.
that?
The particular DOMA decision not to defend the Defense of Marriage Act was one that I'm not able to talk about for the following reason. When I joined the administration, I signed an ethics pledge, and what the ethics pledge said was that you will not work on anything that your former employer is involved in for 2 years, first 2 years of your service. My former law firm, Jenner & Block, brought one of the legal challenges to DOMA. And so as a result of that, I was recused for 2 years from having anything to do with DOMA. And it was during that 2-year period that the Attorney General and the President made the decision that they were going to stop defending DOMA. And I have no insight into that because I just didn't play any part of it. But I did, of course, then litigate the case after that decision was made once I was Solicitor General. And I'm happy to talk about that. But what made that decision very difficult, I think, and challenging was that the norm that we apply in the Justice Department, that Solicitor Generals have applied historically, is that you defend the constitutionality of statutes when they're attacked in court, and you don't, and the fact that the statute's been attacked in court isn't an occasion for you as the executive branch to make a judgment about whether you like the statute or not, that you have a responsibility to defend it, even if you don't like it. And there are two exceptions to that that are pretty well recognized historically. One is if the statute is one that looks to the executive branch like it is infringing on, like it's violating the separation of powers by infringing on executive branch authority. And there's an example of that on the court's docket actually for next year. It was a case that was on the docket a couple of years ago and it's come back. Congress enacted a statute in, I think, 2003, which said any American citizen born in Jerusalem is entitled to have his or her passport list Israel as the country of birth. And the executive branch, first under President Bush and now under President Obama, refused to enforce that statute because they believe it infringes on the foreign affairs power of the executive branch. The position of the United States government, going back to Harry Truman, is that we don't recognize Jerusalem as being part of any country right now. What we do is say that the status of Jerusalem has to be worked out by the relevant parties, and until the relevant parties work it out, the United States government is not going to take a position on the status of Jerusalem. That's been the executive branch position since the 1940s. Congress obviously doesn't like that position because they passed a statute that was an effort to make a statement on behalf of the United States government about Jerusalem actually being part of Israel. And so we don't enforce it. And someone has brought, who wants the passport to say Israel, has brought a lawsuit saying I have statutory right to this. Now that's a statute, and normally you would think that the United States government would defend the constitutionality of statute in front of the court, but we're actually attacking the constitutionality of the statute in front of the court, and we're saying that statute violates the separation of powers. So that's one situation in which we don't defend statutes. The other is when we conclude that there isn't a reasonable argument to be made in defense of a statute. That happens occasionally. It happens very rarely. It almost never happens in high-profile matters. And then the question becomes, well, how does DOMA, the decision not to defend the Defense of Marriage Act, fit into that picture? Well, it's not a separation of powers case. Is it one in which there's no reasonable argument to be made? I think you can kind of debate that either way. There's been a vigorous debate about that either way. And then the question is whether, even if there might in some sense be a reasonable argument to be made in defense of the constitutionality of the statute, does the President have the authority and does the Attorney General have the authority to decide that they are, nonetheless, this is an issue of constitutional law that is of sufficient importance that they're going to make a judgment that they're not going to defend it. And there are lots of, there's a very wide range of views out there about the propriety of that. And, on the one hand, of course, the President has a duty under Article 2 to faithfully execute the laws. And one way of looking at that is, well, DOMA is a law, so the President has a duty to faithfully execute it. Another way of looking at that is, well, the Constitution is also a law, and the President has a duty to faithfully execute the Constitution, and the Constitution trumps the statute. And so I think one thing I will say about that is that the way in which the President and the Attorney General worked this out was quite interesting. They made a judgment that they thought that laws that were discriminatory against gays and lesbians should be subjected to heightened scrutiny under the 14th Amendment, and then once you've concluded that heightened scrutiny applied, there really wasn't a justification, even a reasonable argument for DOMA. The question was about heightened scrutiny, really. But they did make a judgment. They could have simply made a judgment that they were going to stop enforcing DOMA altogether, and they were going to effectively just say, no, we're not, we think the statute's unconstitutional, we're not going to enforce it. But they didn't do that. They made a judgment that they were going to allow DOMA to continue to be enforced until such time as it was definitively held to be unconstitutional by the courts. So in Ms. Windsor's case, the United States refused to give her back her tax refund until such time as the Supreme Court ultimately decided the constitutionality of Section 3 of DOMA. Of course, we were on Mrs. Windsor's side, attacking the constitutionality of it in court, but at the same time, we were enforcing the statute. And the theory behind that was that that's a better way to go about it, and more respectful of our constitutional system, because it allows that approach allows the judicial branch to have the last word on the constitutionality of the statute. That otherwise, if it were just a decision not to enforce the statute anymore based on its unconstitutionality, that the executive would then be effectively having the last word on the constitutionality of the statute. But by doing this, the judicial branch was given the opportunity to make a definitive judgment, and the executive branch would then respect whatever definitive judgment the judicial branch made.
Thank you. I think we all, you know, I don't want to go even close to a line, but I think,
Give it a try.
Okay, all right. You know, I think the Affordable Care Act case was, you know, was one of the most interesting cases that's reached the Supreme Court in recent years. Did you have a pretty good sense of how that was going to turn out after oral argument? And more generally, how often after oral argument do you have a pretty good sense of how a case is going to turn out?
So, you know, generally, I guess what I would say, I'll answer the general question, then I'll talk.
Sure.
But you're not close to a line.
Okay,
That's a good
great.
question.
All right, good.
And I'll talk about that one specifically. You know, generally, I would say actually, you have a pretty good sense of how the case is going to come out before the oral argument in most cases. Not all, but pretty much, you know, the justices each justice has a very distinctive judicial philosophy, and they're very, very intelligent. And they basically, in most situations, they follow their judicial philosophies where they lead. And you have a pretty good sense of where that's going to be in most cases. And they have a track record. They've written opinions in many areas, and they tend not to deviate much from what they've said before. And so in most cases, you get a pretty good sense of where the thing's going to come out, even before oral argument. Most of the time, oral argument reinforces that sense of where it's going to come out. Every now and then, oral argument will seem to diverge from the sense of where it's going to come out. But what usually happens is that when the decision comes down, the thing has returned to the mean. It comes out almost always where you thought it was going to be based on the briefing, even if the oral argument has given you kind of a funny signal that it might be different. It's just funny the way that is, but it almost always comes back to the mean. And with health care, you know, I would say, befitting the fact that it was an extremely close decision, I didn't come out of the argument with a sense of how it was going to come out. I thought there were basically three scenarios that were the most likely from among all the possible scenarios in the case. One of the three scenarios was the one that actually came to pass, which was that the Chief Justice would decide the opinion, the case, and be the deciding vote, and it would be based on the tax power. That was one. Another one was that we would win 6-3 on a narrow reading of the Commerce Clause, and another one was that we would lose 5-4. You know, and so I thought, you know, one of those three things was what was going to happen. I didn't have a great sense of which of the three it would be after the oral argument. Obviously, it was a very intense oral argument. There was a lot of hostility to the government's position, but there was also a clue that occurred during the first day of the argument, which was the day that everybody except for tax scholars and jurisdiction scholars thought was totally boring and they didn't care about. That was the first day of the 3 days of argument was on the question of whether a statute called the Anti-Injunction Act deprived the court of jurisdiction. The Anti-Injunction Act is a statute that says that you cannot challenge a tax unless you have first paid the tax and sought a refund and had it denied, which is, by the way, what Ms. Windsor did in Windsor, the DOMA case. Paid the tax and then sought a refund and didn't get it and was suing. Right? And the reason for that is to basically protect the federal tax system. And so if the provision here that requires you to pay a tax penalty if you don't have insurance is thought of as a tax, well, maybe the Anti-Injunction Act should bar the suit. The United States didn't take that position. We argued as Justice Alito pointed out to me on Monday in the argument, that you're saying on Tuesday that it's a tax, but you're saying on Monday that it's not a tax. I had a technical answer to that, but
Lawyer's logic.
But it was, it's really interesting at the argument on Monday, because the United States was not taking the position that the Anti-Injunction Act applied. The court appointed an amicus to argue that view of the case. And that lawyer did an excellent job. And that lawyer went first and stood up and said the Anti-Injunction Act does bar this suit. There's no jurisdiction now. Here's why. It was clear the court was not buying that. And so then I went second. And so I spent a few minutes of my time just reinforcing the basic points as to why we thought the Anti-Injunction Act should be read not to apply in this situation. But then I realized that I had an opportunity there, because a big issue in the case in terms of the validity of our argument that this was an exercise of the tax power and could be upheld as an exercise of the tax power was how you thought about the mandate in the statute. There are two linked provisions in the statute. One of them said you have to have health insurance. Okay? It just said you have to have health insurance. And then there's another one that said if you don't have health insurance, you have to pay the following tax. And so the question was whether the mandate provision was a freestanding obligation that had legal force in any way other than that you had to pay tax if you didn't have the insurance. And it was very important to our position to advance the view that there was no consequence to not having health insurance except that you had to pay a tax. Because if there were other consequences, then it was more than just an exercise of the tax power. But if the only consequence was that you had to pay the tax, then you could justify it as an exercise of the tax power. One of the arguments that had been made, not by us, but by the challengers to the law for why the Anti-Injunction Act didn't apply, was that they weren't challenging the tax, they were challenging the mandate, which was a freestanding provision. So I did my first 10 minutes or so, and then I realized I was in pretty good shape. And so I spent the remaining part of the oral argument saying, well, there are good reasons to think the Anti-Injunction Act doesn't apply here. But there's one really bad reason to think that, and that's the reason that the NFIB is advancing, which is that the mandate is freestanding. The mandate isn't freestanding. And I spent all this time hammering that point, that the mandate isn't freestanding. And that was really arguing that the tax power constitutional claim and not the Anti-Injunction Act claim, but it was sufficiently connected. I could do it, and most of the argument went very well. And then the lawyer for the NFIB, who were the people challenging the law, got up after me and tried to make this argument that, no, the mandate is freestanding. And then Chief Justice Roberts said, well, what's the consequence of not having insurance other than having to pay the tax? And then he gave a dramatic pause, and then he said, nothing, right? He leaned over. And I sat in my chair and I went, oh, that's good. That's good. He gets this point. And so, I didn't know at that point that he was going to be ultimately going to go our way in the tax power argument. But you will see, if you actually look at the opinion, the Chief Justice cites back to the transcript of the first day where I made all these concessions. They kept saying, so you're telling me that if you don't have insurance and the FBI requires you to fill out a form and ask you whether you violated any federal law, you can say, no, I haven't. And I said, yes, you can say, no, I haven't. And every one of those hypotheticals, I said, that's right, that's right. And you look in the opinion, and that concession is there. And so that was actually kind of a key moment in the case, as it turns out. But not only as it turns out, one reason I was optimistic, despite the rough nature of the oral argument, that we might pull it out on the tax power was because of that exchange and what the Chief Justice said on the first day. So.
Certainly by the time it got to the Supreme Court, nobody was surprised to see that there was a close division. It's going to be a close case with respect to the Commerce Clause part of the case. But when the lawsuits below were initially filed, there were plenty of voices saying this isn't a close question. In fact, Charles Freed, one of your predecessors, who's quite conservative, I think he used the word frivolous to describe the constitutional challenges under the Commerce Clause.
He went on TV and said, I will eat my kangaroo skin hat, which he waved onto if the statute is declared unconstitutional. So he had a pretty strong view about it.
He did. Did you see it right from the beginning as a case that was going to the Supreme Court?
Absolutely, yeah. Again, I'm sorry, maybe it sounds immodest or whatnot, given the way history has unfolded here, but I was really worried about this right from the get-go, and lots of people. And I actually think that the smartest lawyers working on this case in the government who were really bearing down on it were very worried from the get-go. And the reason was that there actually just wasn't any binding precedent. This was a statute that imposed an obligation that was different in form from many federal, from most exercises of the commerce power, and other situations in which federal statutes required purchases of something tended to be conditional. For example, if you were going to operate an interstate trucking company, then you must purchase insurance. So it had an if-then quality to them, and this statute didn't have that if-then quality to it, and so therefore, as a result, there wasn't a precedent that you could point to. You were basically arguing about judicial philosophies and base first principles about the scope of the commerce power, and because you were operating in that world of first principles and basic philosophies, there wasn't a lot of constraining force. You could just say this is well within our tradition, or you could say this is a step past our tradition, and it was hard to refute either argument, and therefore I thought it was quite risky. And that's also part of the reason that the tax power argument was so important right from the get-go, and that the lawyers litigating the case understood it was important right from the get-go, because it was a way out of that problem.
Right.
You could say, well, you don't actually have to figure out whether this is within our traditions or a step past our traditions, because there's a whole other way of thinking about this case that allows you to resolve it without dealing with that quite vexing question.
Right.
So.
Right. So it's such a fascinating, case. I want to make sure I could go on, but I want to get to some of these questions. This question says, many of the Supreme Court judges seem to have, and it's in quotes, partisan agendas. And there's a two-part question here. Do you agree? And how do you take those agendas into account as you prepare your arguments?
So I don't actually think, there was this really interesting article that Adam Liptak wrote in the New York Times this past week that tends to document facts, which are, facts are what they are, that shows that at this point in all the ideological cases, the justices tend to break down on the basis of whether they were appointed by a Republican president or a Democratic president, and that's quite unusual in American history that that's the case. And I think that that is what those facts are what they are. But I would push back a little bit against the idea that they have partisan agendas. I don't think that captures it accurately. What I think they have are well-developed judicial philosophies. Now, those and they're different from each other, and they're it's legitimate. There are competing views about what legitimate judicial philosophies are, or what's the legitimate approach to interpreting the Constitution. And these are very smart people, and they've been thinking about these issues a very long time in most cases, and they have views, and they act on those views. That's different from saying that they're partisan. And this, partisan seems to me to be a sense, are they trying to advance the political agenda of one party or another? I don't actually think that's what they're doing. And you will see times, certainly, when you will find justices that they hew to their judicial philosophy, and they do issue opinions that run counter to what you think they would do if they were engaged in a partisan enterprise. And so I just think that's what's going on rather than partisanship. I don't think it's really a political thing that's happening in the court. I think it is a working out of competing views of how you interpret the Constitution, competing views of how you approach the interpretation of federal statutes, competing views of the relationship between federal and state power. I just think that's what's going on, and that's what you're seeing. But having said that, we certainly do take those competing judicial philosophies into account in shaping our positions. Surely we do, because we want to win our cases. And in order to win our cases, we have to get 5 votes. And so we do think about how best to get 5 votes. Now, we don't approach it the way lawyers in private practice would. When I was a lawyer in private practice and I had a case before the Supreme Court, I would try to figure out who my 5 votes were, and I would, design our approach to try to get the 5 votes, or maybe get 6, a little margin of error in there, a 6th vote or 7th vote. But if there was somebody who I knew was completely hopeless, was never in a million years going to vote for us in the case, I would devote no energy to either in the briefing or in the oral argument to trying to persuade that justice or even engage with that justice. In fact, in oral argument, when I was in the private sector, if there was some hostile questions coming from a justice that I knew I had no chance of getting, I would try to answer the question in as few words as possible, so, like 3 words, blah, 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 and then turn away and talk to somebody else so that, I just, I'm going to shut this down because this is not helping, In this job, it's really different. When you're the SG, you shouldn't do that, and you can't do that, and I don't do that. There are reasons of principle for that because we are representing the executive branch of the government before the court, and there are also pragmatic reasons because I may be at the podium in a case in which there's a certain constellation of justices that are most likely to help us win, and there are a couple whose votes are totally hopeless in that case. But one of my colleagues may follow me to the podium in the very next case, and those 2 justices who we have no chance of getting in this case might actually be the decisive votes in the next case. And so if I have alienated them by not giving them full respectful consideration in my argument, it's certainly not going to help us win the next case. And that's just a way of crystallizing the point that we have an institutional mission here. We're representing the United States, as I said, in 50 or 60 cases every year before the court. And we've got to have a respectful exchange with all of the justices all the time. And so that tends to lead us to approach the question of how do you take their differing judicial philosophies into account a little more subtly. We will try to write arguments that are going to appeal to a broad range of perspectives. I don't know what the right metaphor is, tapestry, symphony, whatever, but you weave into it lines of argument that you think are going to be particularly likely to persuade the justice whose vote you really think you need to win. So you do it that way, but you don't kind of make the blatant pitch for a particular justice's vote.
Interesting. One question was, do you moot, do you practice before oral arguments in your office?
We have very intense, it's funny, in the old days I guess they didn't do moot courts, but when Ken Starr became SG in the late 1980s under the first President Bush, he instituted a policy that everybody who was going to argue a case, including the SG, would do 2 moot courts. And that's been the policy since, and I do 2 moot courts for every argument. And they're incredibly, incredibly helpful and valuable to me. We have 4 or 5 of the younger lawyers, assistants in the office, and then 1 deputy, and then other lawyers in the Justice Department or the executive branch who have worked on the matter come to the moot court. We have them in our conference room. It's about an hour to an hour and 15 minutes of questioning, in roll, and then another hour to hour and 15 minutes of discussion afterwards. And the lawyers in my office are like so imbued with the court and its jurisprudence and the justices and how they think that they just understand how the cases are going to look to the justices. And so as a result, I would say 90% of the questions I actually get asked at oral argument, I get asked in the moot courts. So it's like, if you're getting asked 90% of the questions, that helps you get ready, really. You can be pretty efficient in getting ready. And sometimes it's a little spooky because they will ask questions in the moot courts using exactly the same words that the justices will then use. Like the one time, last year I argued a case about standing, and I was making a point about the redressability part of the standing analysis. And one of the questioners, one of the lawyers in my office in the moot court said, "Aren't you slicing the bologna a little too thin there?" And I said, "Oh, no, I'm not, and here's why, blah, blah, blah." And I get to the argument the next week, and I'm at the podium and arguing the case, and the Chief Justice says, "Aren't you slicing the bologna a little too thin?" Whoa, man, that was spooky. But it just shows you how good they are. And then the other thing that I really, it's a huge advantage in getting ready for arguments, and it's related to the point about moot courts, is that because I have this position, I'm very fortunate in that I can call on the resources of the executive branch to help me get ready. I'm going to give you a good example of that. Last year I argued a case about whether you can get a patent on a human gene when it's been extracted from the body. You can't get a patent on a product of nature, and so if the gene's in your body, it's a product of nature, you can't get a patent on it. The question is, if it's taken out of your body, is it transformed into something else you can get a patent on? Well, the United States government had a view, and the view was you shouldn't be able to get a patent. It's still a product of nature. But in order to explain why it was still a product of nature, you really needed to understand genetics and biology. And the last science course I had taken, I think I was a sophomore in high school, you know, and I didn't even take, you know, biology for poets in college or anything like that. So I did not know any science, any biology, any genetics, anything. But what I did know was the phone number of Francis Collins, who was the head of the National Institutes of Health. And so I called Francis and I said, well, will you come to my moot courts? And he said, sure. And that was particularly helpful because before Francis Collins was the head of the National Institutes of Health, Francis Collins was the head of the Human Genome Project. So Francis knew genetics. So he came to my moot courts and he asked questions and helped me formulate answers. But even better than that, he sent a team of 3 genius scientists from NIH to come down and give me a tutorial. So I had these 3 scientists came into my conference room with their whiteboard, and we had 3 hours. And by the end of the 3 hours, you know, I understood some genetics. I understood enough to be able to translate into common sense terms and common sense language some of the scientific concepts that were important to understand to resolve the case. So a lot of the getting ready for argument does revolve around the moot courts and related processes. And that's a little different than when I was in private practice. When I was in private practice, I did moot courts, but I would block out like a couple of weeks before the argument and really delve in and spend all my time for those 2 weeks working on the case, trying to get ready. And I do not have the time to do that in this job. I don't have anything like the time to do that, but the moot courts really do make up for a lot of the lack of time. So.
Do you have individuals in your office who are assigned to Justice Sotomayor or Justice Scalia, or do they play different roles?
No, not exactly, not exactly. But they don't, you know, they can, as I said, they're so imbued with the court and each justice and how each justice thinks that they make sure that they shape the questions in a way that that reflects the different perspectives of the justices. Okay. They don't exactly role play. In fact, in a moot court, somebody may be asking the kinds of questions that Justice Scalia would ask me, and then 20 minutes later ask me the kinds of questions Justice Breyer would ask me. It might be the same assistant, but they are role playing in the sense of trying to think about, you know, what am I going to get hit with?
Okay. So that would be kind of nice for office Halloween parties otherwise.
No, I don't think so, because that might get out, and that would be bad. Right. That would be bad. No.
Here's a question. Can you tell us about the special robe the Solicitor General and attorneys in the office wear?
Oh, it's not a robe. It's a morning suit. You know, it's one thing I can tell you about morning suits is that in the United States of America, they are very difficult to come by. The British have them in abundance, but we wear morning suits. And so, you know, it's a long coat and a vest and a silver and black and white tie and striped pants, and which is all well and good for the men. But of course, we have a lot of women in the office too, and it poses a difficult situation for them. And they've taken different paths to deal with that. When Justice Kagan was SG, she just eschewed it altogether. She would wear like a pantsuit. And some of the women lawyers in the office do that now. Some of them go like full morning suit. They have the full morning suit outfit. Some of them do like modified morning suit. They'll have the morning suit jacket, but with a skirt that's in the same fabric as the pants that a man would wear. And it's, you know, it's quite a tradition. It goes back a long way. When I first assumed the office, had a thought about maybe about changing it, because there's a way in which it doesn't seem entirely fair to the women. And but I will tell you a little story that will make clear that this is not going to change anytime soon, which is when you first become SG, you get officially presented to the court. You know, the outgoing SG takes you up there and says, "I want to present the new SG." And so they wanted to do that. I got confirmed and took office in June of 2011, and the court wanted to do that in June before they left for the term. And I didn't have a morning suit because, as I said, they're very hard to come by in the United States. And there were some old morning suits that are around the office, kind of legacy morning suits, but most of them seem to have been ones left behind by Howard Taft when he was SG. You know, they were like, so they didn't really do me a whole lot of good. And anyway, so the counsel of the Chief Justice called and said, "We'd like to schedule this thing, presentation for the following Monday. It was like on a Wednesday. He said, we're going to do it the following Monday. Can you do it? And I said, sure, I'd be happy to do it, but here's the thing. I don't have a morning suit, so I'm just going to wear a suit, okay? And so the counsel, the Chief Justice said, let me check with the Chief Justice. I'll get right back to you. The phone rang like 90 seconds later. And so the Chief Justice says you'll be in a morning suit. So I heard that. I'm thinking, we're not changing this. And so I had to scramble around, and I was able to find a pair of slacks, morning suit slacks that fit, and from the kind of legacy slacks. And I was able to borrow a vest from one of the deputies, and there were some jackets that kind of sort of fit, but the jacket that came closest to fitting, the problem was the sleeves were up like that, that just the arms were way too short, but that was all I could do, so I had to wear that jacket. So when I got presented, I stood like this. So the members of the court wouldn't see that the thing was like up there. But anyway, so that's the deal with the morning suits.
I'm going to paraphrase a longer question here, which expresses concern about the fairly narrow slice of society from which the 9 current members of the Supreme Court are drawn. And the question here asks whether you think there's legitimate reason for concern that about a failure to appreciate the complexities and breadth of experience that Americans face these days.
I would look at that a little differently, because actually I think that point is accurate if you're thinking about their professional backgrounds from which the justices come. They almost all of them were graduates of Harvard or Yale Law School. Almost all of them were federal appellate judges. Almost all of them had positions in the executive branch of the government before. So they come from a pretty narrow perspective in that sense. But if you actually look at their personal life experiences, ways and where did they grow up and how did they grow up, there's actually a lot of diversity there. And so I think the problem, I think look at where Justice Sotomayor came from, look at where Justice Kagan came from, look at where Justice Scalia came from. I mean, Justice Ginsburg, Justice Scalia and Justice Ginsburg, grew up in ethnic neighborhoods in New York, and Justice Sotomayor grew up in the Bronx, and so I don't think it's so much of where their roots are, as that they were such exceptional people that they succeeded to the very highest levels in everything they did, and got into great universities, and then got into great law schools, and then got great legal jobs, and became judges. But there is a way in which they all share the same perspective because of the professional lives they've led. And you can debate whether that's on balance good or on balance not so good. One side of that argument is that it's a good thing, because when you have people who have by and large been judges before being justices and are really imbued in the legal culture, that they decide cases according to law. It makes it more likely that they're going to exercise the judicial power that the Constitution gives them according to law, and thinking about it like lawyers, and it should be decided on the basis of legal principle. And that you can argue that's a good thing, and I think the Chief Justice has said that. You can also make the argument that there's a real value that someone can add, say, like Earl Warren, who had been governor of a state before being on the Supreme Court, or Sandra Day O'Connor, who had had a career in the state legislature and was I think, Speaker of the State House or President of the State Senate, one or the other, and that perspective is really valuable to bring to the court, and that other sort of understandings of the practical workings of government and the way government programs play out in practice and the effects they have on people's lives, that you might, it does seem to me that you could make an argument that there's an advantage to be gained from having some of that perspective on the court, and I do feel like, I thought Justice O'Connor was a terrific justice, and she had I thought, a capacity to try to find ways to bridge gaps and bring practical considerations to bear that I thought was a good thing.
Right.
So.
Are you nervous during oral arguments?
Oh yeah, sure. Although the argument, I mean, I'd say I'm nervous before the argument. The argument itself is a little bit like, any of you been whitewater rafting? You know, it's a little bit like that. You know, you get on the raft and you push off, and the next thing you know, you're at the bottom of the river. You know, that's kind of what an oral argument is like. You're just off and it's going. You know, and so you don't really have much opportunity to be nervous during the argument itself because it's all happening. It all happens so fast and so much going on. And so, but in the run-up, sure, you look at every advocate. There's a fellow, Ed Needler, who is a deputy in my office. He's amazing. Justice Ginsburg has described him as a national treasure, and that's an understatement, if anything. He's been in the office since the Carter administration. He's actually been in the Justice Department since the Gerald Ford administration. And he has argued like 126 cases before the Supreme Court, right? So you'd think this guy's argued 4 cases a year before the U.S. Supreme Court every year for decades on end, right? You'd think, how could it possibly faze him? You see his hands shaking before he goes up there. And you see every great advocate, you see him standing there at the podium, name your great advocate. You know, I won't embarrass anybody by raising their names, but you look at them, there are definite signs of nervousness, either shaking or sweaty brow, whatever. Everybody. And you know, and that makes sense, right? The stakes are high, and you want to do your best, and that kind of nervousness does actually propel people to do their best, I think. And so, but everybody's nervous. Yeah.
Right. Well, I told you, hours go so fast up here, right?
We can take another more question
if anyone
you
else
want.
would
I don't
like-
want to mess
yeah.
up the schedule for the day, but you know, I'm happy to take you don't have to write them down. Even just you can raise your hand if anybody has any more questions. Or if not, we can stop.
Well, go ahead.
Yeah.
My name is David Ruoff. Thank you for coming to New Hampshire. You discussed earlier kind of the role that the President and the Attorney General office play in making decisions that you are ultimately taking before the court. You touched on it briefly. I mean, how mechanically does that work?
No, you know, I didn't actually mean to imply that the Attorney General and the President have a role in the positions we take. It's extremely, extremely rare that they get involved. Extremely rare. The vast majority, I'm the last stop on the train, basically, in the decision-making process. In theory, of course, the Attorney General runs the Justice Department, and I work for the Attorney General. And in fact, as a formal matter, the power to decide what the United States position is going to be is one that, by statute, is given to the Attorney General, and the Attorney General, by regulation, delegates it to the SG for Supreme Court matters. So in theory, the Attorney General has this power, and then, of course, in theory, everybody reports to the President in the executive branch. But the way the thing works, as I said, is that I'm the last stop on the train for making decisions, except in very, very, very rare instances. And what I consider it part of my job to make sure that the Attorney General understands what decisions I'm making and why. And so I'll meet with the Attorney General like monthly, but it's much more in the nature of, here are the cases that are coming up, here's what we're doing in this case, here's what we're doing in this case, here's what we're doing in this case. The Attorney General would be free, because he has the authority to do it, to question any of that if he wanted to, but it doesn't happen. And that's the norm, not just now, that's just the norm. You know, that's the way the system runs, because the idea that the SG is supposed to exercise independent judgment on behalf of the interests of the United States is a very well-entrenched principle, and it's one that attorneys general respect, and it would cause them a lot of headaches if they didn't respect it, I think, and the headaches aren't worth it. I think they also realize that they benefit from, that the Attorney General and the President benefit from that kind of independent judgment, because it allows them to avoid, say there's some approach that they think would be in the interest, in their policy interest, but just really conflicts with well-established views that the government has taken over many decades that reflect many decades worth of experience, that this is what the United States needs to say in order for the government to function effectively in this area, that if they were to depart from that, it's likely going to end badly in lots of different ways. And so the independent judgment actually helps them avoid making bad decisions, which is, I think, one good reason why they respect it, but they do respect it. And so a case like DOMA is an extremely, extremely unusual situation in terms of the involvement of the Attorney General and the President. You had a question over there.
Yes, I guess I'm just interested in, so a lot of what you've talked about is, you know, the legal considerations and the legal arguments and the legal philosophies of the judges. But if you think a little bit more broader, the cases that do come before the Supreme Court have huge social implications. And I guess I just wonder, in the work that you're doing, how do you sort of balance those out? I mean, I realize that your fidelity is to the law and to the Constitution, but how do you, I guess just as a human being, how do you work through the fact that some of the cases that you have to argue are really, really, they're going to have really huge ramifications for people's lives?
Well, you definitely, you're not, you know, I think you hold both of those things in your mind at the same time. As you said, you're right, the fidelity to the law is the essence of the job. But in thinking through what our position should be and why our position should be what it is, you're not insensitive or blind to the consequences of going down one path versus going down another. In fact, I think it's important that you think, in the job of SG, that you think carefully about that. Now, sometimes you may come to the conclusion that the law, as it exists now, and the interests of the United States, as you best perceive them, require you to take a course of action that is going to result in social effects that you're not happy about. That happens sometimes. On the other hand, there are times when you can make a judgment, I think, that the matter at hand is important enough and the stakes are high enough and the consequences are significant enough. And this is particularly in cases where we have amicus type cases where we have a choice whether to participate or not, that the importance of those kind of consequences can be a reason to think about it being appropriate to come into a case. That's something really is serious at stake here, and it's important that we speak for the United States in this situation. So they do. So that does come into play in that way, certainly.
Just a quick, in the amicus cases, would it ever be appropriate, when the Supreme Court takes a case, quite often, it's pretty easy to predict what they're going to do with it. Does the position that the United States takes ever turn on a prediction about which direction that the court is going in, thinking, if we come in on the side of the side that's going to win, we may be able to shape the reasoning and have an impact on the reasoning that the court would follow?
That's a really complicated thing.
Yeah.
The answer is, it's not the case. It's not been my experience that we have ever said, we really think the interests of the United States would be served in advance by this outcome over here. We know that the court's going to do the opposite, so we're going to urge the court to do the opposite. Right. But try to shape it. That doesn't happen. But it happens at a more subtle level. And it does influence, we may think that it would be a better policy outcome if this certain class of claims, say, weren't preempted by federal law. There's a lot of amicus cases are preemption cases where the question is whether federal law preempts state tort claims or state contract claims. We might think that, it might be a better policy outcome if there's no preemption here. But the Supreme Court's doctrine is so overwhelmingly clear that they're going to find preemption, that we would sacrifice a lot of credibility to say no preemption. Right. And therefore, what we would do in that circumstance would be to try to, recognize, because part of our job, we don't just go in and say, yes, you've been saying, you have 8 cases saying there's preemption in these circumstances, but guess what, you're wrong. Overrule those cases and do the opposite. We do that only, we ask them to overrule a case only in extremely unusual circumstances. And when, not just even when the court's criteria for overruling are met, but when we think it's just imperative. And that's because of this notion of credibility and preserving our credibility over the long term. And so in a situation like that, in a preemption type situation, just speaking hypothetically here, we might welcome in and say, you know, we recognize that the outcome of the question before you in this case follows from the prior precedents, but you ought to be thinking about shaping that outcome in a way that reflects these kinds of considerations that are important to the United States. So that's how it would factor in, I would say. So. All right. Well, thank you very much.
Thank you very
That's
much.
great.